afternoon, everyone, and welcome to the closing event for the PNLA Conference, The New Normal, which launched earlier this year in May. In case you haven't met me, my name is Jana Patel. I'm the South England representative for the PNLA. So firstly, thank you all for coming today. This is the first time that we've held a live Q&A event following on from an online conference. So it's really encouraging to see some of the delegates today. So thank you for coming. And I'd also like to thank our speakers, our esteemed speakers, for their contributions. It does take a lot of time to prepare a talk, record it, which doesn't always happen on the first take, as I know from first-hand experience, and then obviously provide the reading material and obviously attending today, so thank you. Also want to say thank you to Outer Temple. Thank you very much for this fabulous room. It's really, really great, thank you. And for hosting the drinks reception later on today. Right, I think that's everything. Should we kick off?
Hello, yeah. I'm Katie Manley, President of the PNLA. I will say a few words in closing, but my task at the moment is to kick off the questions. So my first question is to Richard Hitchcock of Outer Temple Chambers. His original topic, you've seen from the film, was some thoughts on limitation, knowledge and concealment, section 14A and section 32 of the Limitation Act 1980. The question is, Richard, thank you very much for your timely review of section 14A and section 32, which is anticipated will be extremely useful in the light of the surge of lender claims predicted to arise, particularly by fellow speaker Nick Curling of TLT and others. Do you have any thoughts on the practical side, for example, evidence to look for and issues in relation to conveyancing solicitors and surveyors in this context?
Thank you very much, Kate. If I could first of all just in what you've been talking about fire exit, I've been told that if you appear on the window, the balconies, you'll be shot by armed police. So although you won't be burned, at least while you're alive, it isn't a great idea. There's never been a fire, so it's a low risk. Thank you very much for that question. I'm operating slightly behind the line in relation to it, because the closest I've ever got to a conveyance has been in my personal life. I have no claims that have arisen out of it, of any of them, in fact. But it's quite useful to see that question as really a way into what's a critical question in all limitation cases in which limitation is a material issue. And I say material because, in my experience, sometimes it's used even when it isn't really a material issue. In other words, people claim that there's a limitation problem for a claimant when on close examination there almost certainly isn't, and it's been put in as something of a bargaining chip with view to a future mediation. Knowledge for section 14A purposes, which triggers an obligation to use reasonable diligence in searching. I'm being slightly naughty here because I'm using reasonable diligence, which occurs in section 32, but effectively it's the same test. Have you been put on notice to discover the material facts? It well pays scrutiny of solicitors and surveyors' entire files in relation to transactions, both files that existed at the time of and running up to the conveyance or transaction, and also the file which follows on from that. In other words, take a property, for example, has anything occurred in relation to that property subsequently, which might have given rise to knowledge, which ought to have put a defendant on notice, for example, that material fact has not been passed on to a claimant. And so I think sometimes the evidence which people look to identify whether or not there is an opportunity to attack a claimant, or indeed support a claimant, depending on who one's acting for, in the context of a case which is outside the primary period, is sometimes surprisingly narrow. So don't narrow the search. Look at anything which you think could possibly reasonably be said, if you're on the defendant side, to have triggered knowledge. And obviously be aware of that in terms of protection from the claimant side. So don't set out your case on why it is you should be permitted to bring your cause of action despite the fact that you're outside the primary limitation period, without fully scrutinising the evidence which ultimately comes to light.
Thank you.
I was also going to say we could talk about why this whole area on section 14A is governed by Supreme Court of the House of Lords, I think, their decision in Fawcett's, which is discussing earlier, probably wrong, but unfortunately it's there. That's quite interesting. And
why do you say it's probably wrong?
Well, of course it's not wrong, because we are taught the law by the House of Lords, and so therefore it is what it is. And there's no point suggesting to any other court that they should just like smile at it and consign it to the waste in the history. But the analysis, while obviously erudite and intellectually impressive, doesn't precisely follow the statutory test. If limitation exists only, Limitation Act is the entirety of the provisions, the relevant provisions which one looks at to decide whether a claim is entire or not. And so our most powerful court in determining a case, you would think, would first of all interpret the Act insofar as interpretation was necessary, and then precisely follow the provisions of the Act in answering whatever the issues that were before it. Now, if one reads the House of Lords speeches, you could forgive yourself for asking whether or not that's what the House of Lords did in Fawcett. But it's a slightly mysterious point, because we're saddled in the nicest possible sense of the word saddled with it, as we are with all Supreme Court decisions. The ones that tell us that the Supreme Court doesn't keep changing its mind about how you interpret contracts. Slightly on left field there, but
Thank you. So our second question is for Nicholas Hill. His talk was on pensions and financial. It was a pension and financial services update. So Nicholas, thank you very much for your review of Adams and Carey in a pension SIPS context and its related implications. Excuse me. What steps do you think solicitors should take when receiving calls from potential clients with troubling investment experiences to ensure that potential claims are looked at by those with the right expertise?
Thank you very much. I suppose the first thing to say is I clearly predicted in my talk, and we've seen it, that Adams and options would be appealed and the Supreme Court would give permission, and of course the Supreme Court did not give permission. So don't do what one set of solicitors who recently shot at me did and say, well, we're just waiting for the appeal to be heard in Adams and options, then we're really going to get on top of that case. Don't do that. So, we have the law, it's a Court of Appeals judgment, we need to be on top of the Court of Appeals judgment, and we need to be on top of the intricacies in that judgment. I think probably 3 points answer that question. The first one is you need to think quite carefully about pensions. You need to understand what a SIP is and what the investment in a SIP is from a pensions perspective. Because we all talk about pensions if we know what they are and how they operate and how they interact. It's a big pot of money, and you can do this, you can do that. Actually, it's a bit more technical. And the Court of Appeals analysis of changing the asset in the SIP and what that means, and whether you fall within the regulated activities orders, so on and so forth, does require quite careful thought. My second point, I suppose, would be to think about speed. In these sorts of claims, particularly pensions and selling claims, professional negligence arising from pensions and selling, you have the operators, you have the introducers, you have trustees, you have employers, you have a range of potential targets, but the financial viability of those targets is ever-changing and shifting, particularly with unregulated introducers in a foreign jurisdiction and with authorised operators. So you need to think quite quickly. You want to be at the front of the queue of potential claimants. You know, in Adams and Options, I think this Court of Appeal, which was just newly pointed out that the SIP operator in that case had 288 clients who had invested in store pods in Blackburn, and that should have run alarm bells.
Yeah.
You want to be at the front of that queue with your claims if you can. And I think the third point links quite neatly to what Jonathan's talked about, which is that you need to think about group claims. There's an economies of scale problem in SIP cases. I think the case in Adams was worth £55,000 SIP. That case went all the way to the Court of Appeal with, I think, 3 or 4 KCs appearing with the various policies. The costs in that claim alone were hundreds and hundreds of thousands of pounds. More recently, I've been involved in some of the British Steel pension scheme selling cases in Wales at an office in Bristol. And the problem again there is there are cost risk issues for individual claimants pursuing claims, but group litigation, insurance and so on is absolutely essential to making sure those claims can properly be brought. The interests of District Mrs. X, who's the biggest asset in their life in the form of their pension, has been stripped of all its value. So you need to think really carefully about funding, think about our group litigation. But I do think there is going to be more and more of this sort of litigation. Notwithstanding the fact that investments in SIPs right now, of course, are suddenly doing quite well, as long as they're not in storage pods in Blackburn because of market movements. So, for example, in British Steel, just adopting Richard's approach to take the segue, a lot of the claimants there, actually, their financial position now is that they've suffered no loss. So, although they transferred out of a gold-plated pension scheme in Wales, their investments in their SIP are now doing so well that they're doing better. Of course, the huge problem for them is, will they be doing better in 25 years? Probably not. But right now, they've suffered no loss. So there are lots of bits to think about, lots of moving pieces of the puzzle when pensions and financial services are involved. And speed is actually really those would be my thoughts. I'm interested if Jonathan suggests that they can't really pursue these group claims, but I think there's some problem.
Can I ask an additional question? Is that allowed? Please. So what kind of suite of experts would you have in those kind of large group litigation claims?
Well, it's really just a question about value. Do you need an expert actuary, or actually do you try and crunch the numbers yourself? I quite often am asked to crunch the numbers, and I get out the audit tables to look at life expectancy.
Oh wow!
And it's not straightforward. Discount rates. Well, where's the discount rate now? Is that the right discount rate? How all those sorts of things. So I always want an actuary, but clients very rarely want to pay for it. That's really, I think, the only expert you need. But then you need to be very carefully as a lawyer think about the pensions aspects and about the financial services aspects. So I was chatting to one of the delegates earlier about the COBS claim, Adams and Options. It's not really been grappled with yet. So you want someone who's familiar with financial services aspects just as much as pensions aspects. But I mean, everyone in this room could do these claims. They just require quite careful thought and unhelpfully.
Thank you.
Next question to Jonathan Sachs, who's partner of Pitmans, talking about claimant group claims. Jonathan, thank you very much indeed for your consideration of the attractions and pitfalls of engaging in group litigation. However, do you consider that certain types of claim are only likely to be possible taking account of their complexity and well-resourced dependence if firms like yours are willing to set up the administrative and practical resources required? Secondly, do you think that there is scope for collaboration between firms with this capability to try to share resources required to win such claims?
Thank you very much. The setting up and administering a group claim is actually not that expensive. There's a company in Essex called Case Pirates who will provide you with the technology to do it if you don't have it in place in your But the key thing is to have a proper website where people can become clients on the website. A sort of third, fourth style level of due diligence where people can become clients by simply opening their mobile phone, putting their photo and their passport into it. And the third, fourth system can be dealt with people all over the world, except for South Africa and Latvia. So, we've had clients in Malaysia, clients in Taiwan, who went through the third, fourth system. So, yes, if you don't have a system and you have to take passports and utility bills for 2,000 people, costs will be outrageous compared to a firm who does have those systems, but it's not very expensive. Another problem is paying the clients when you get the money. And there's a classic case where one poor firm paid it to the wrong people and sued for £32 million at the end of a group claim. So you need to take real care about that. But we outsource that to the firm of accountants to do. So they're quite happy with the work. And there were a number of examples where we had 3 clients where the wife has claimed our client has died and she would like the money. So clearly there needs to be a little bit of checking as to whether he really has died. And those issues can be quite difficult. So no, I think that any firm can really do a group claim. Whether you could do a group claim which involved 100,000 claimants, I think it is questionable. It probably has failed to be many firms who would have the ability to do that. But I think the key thing to make it profitable is what Susan Dunn says about group claims. She doesn't want to pay £100 an hour for the value to spend every day, 6 hours a day, to filling in Excel spreadsheets. You've really got to get proper IT systems in place. Do you think there's scope for collaboration between firms with the capability to try and share the resources required to win such claims? I think it's very important. And the history of professional negligence group claims is that because of aggregation, is that one firm gets in ahead of the other and scoops all the money. And there was a famous claim involving property in Italy, where a small Northern Ireland law firm got in ahead of 2 major London law firms and scooped most of the money in aggregation. And I'm sure if there was a little bit more collaboration, that might have been prevented. Of course, if you're going to have 2 law firms instructed on a group claim, the judge will want there to be only one law firm on the record. So there'll have to be collaboration to decide who does what in a group claim. There is a collective redress lawyers association, which I really should join, which has Edwin Cove, Hansfeld, Keller, Postman, Nide, Milberg, PGMBM as members. And they're trying to promote collective redress in England, especially litigation, which can only be done in the collective, but in the competition appeal tribunal. I think that must be a good idea to try and make it easier to do collective group litigation. In the claim which I recently settled, the costs for clients recovering around £40,000 each was £300. So if you were to, at the point of the neck base, if you were to do each case individually, you just wouldn't be able to do it profitably.
How many cases was
But I need to be careful, because otherwise I get to breach the confidentiality.
Okay, sorry.
So, but if you deal with proper IT systems, group claims can really be profitable. And we've been approached by caravan owners who want to sue the holiday park where they each spend £70,000 on caravans. They're being basically kicked off or ramped up site fees. Those people will never be able to sue the Paramount mark around the grouping of the claims, but no third party fund will be funding it unless you've got these IT systems in place. But no, you don't need to be D-Day or Asfeld, and there's a company in Essex who will do it for you.
Right, so the next question is for Helen. She spoke on insolvency practitioner negligence. So Helen, thank you so much for your review of this tricky area of professional negligence. Do you think that insolvency practitioners have any professional duty to investigate, and if there are merits to pursue professional negligence claims on behalf of the estate?
Absolutely. I think they clearly do. Their whole reason d'etre is to get in the assets of the estate. And if there's a possibility that there's a valuable professional negligence claim, then they have a duty to do that. My recent experience has been that IPs are getting a bit more savvy about pursuing litigation. There's a lot more funding options available to them. CFAs, ATs, litigation funders, the market's quite mature now in insolvency. And so for those reasons, professional negligence claims can be quite an attractive option for an IP, particularly when the defendant will usually have insurance, as we know. With the current recession, I would see that trend continuing because the other options, the IP goes after the director. That's the usual approach in these type of liquidations. But the reality is now going through a huge recession. Well, not yet, sorry. We're about to go through a huge recession. The reality is a lot of these directors are not going to have the type of assets available to replenish the pot, which makes the insurance route much more attractive.
Do you think in your experience that there's sort of a routine practice to seek specialist advice from professional negligence lawyers, or do you think it's just sort of there isn't any sort of basic sort of approach to it?
So I think it's a bit of an untapped market for professional negligence. When I've been instructed on these cases, it's tended to be by my insolvency solicitors who need a bit more steer from me because they're a little bit out of their comfort zone. But it's because the IPs will go to the people they're most familiar with working with. So I do think it's worth marketing internally to your insolvency department or just going straight to the accountancy firms. I mean, of course, it's slightly difficult if you've got a reputation for suing those accountancy firms. They want to get the work from their colleagues in the insolvency practitioner department. But if you can square that circle, then it's a potentially good source of work, I think. Certainly something IPs thinking increasingly about.
Great, thank you very much.
So it's back to me. I would like to ask Roger Flaxman, Flaxman Department's question. He spoke very kindly about the changing roles and responsibilities of brokers. Roger, as always, it's incredibly interesting and useful to hear from you the inside track over many years on the development of insurance brokers' practice and resulting legal duties. You mentioned your association with the British Insurance Brokers Association, BIBA. Do they offer assistance to find experts in broking to act for claimants and defendants within the various areas of expertise where disputes arise? Sadly, there are no insurance brokers experts listed in the PNLA specialist section. Do you think that the PNLA could do anything more to encourage broker experts to come forward?
I'll answer the first part of the question. British Insurance Brokers Association deliberately steer away from it.
Right.
Because they see it as a political blackmail. And I would say that the insurance industry changed its spots round about the mid to the late 90s, when a number of experts, or so-called experts in the insurance industry, were creamed by the council, and they were never allowed to do it again. So, and it's particularly, the kibosh was put on it mostly by the American insurance broking community, who said, we don't do this, we're simply not having it. So it's very, very difficult now. Do you agree with that, by the way? Yeah. Sort of contemporaries, it's becoming a me, but you know, if we've been in the same market person. And the point is that the insurance industry generally is paranoidly fearful of the law. And I say that in the context of people who've got suitable qualifications in insurance will very frequently say, I can't tell you that. You have to ask a lawyer. I'm not a lawyer. They won't give an opinion even on basic policy coverage issues. And I mean, that's an issue which I have to face. I do quite a lot of expert work, and I'm often asked, well, can you give an opinion on what the policy covers? And I said, well, I can give you an opinion on what it is covering as far as what it is sold to cover. But of course, now we've just had the monumental decisions in the FCA test case, about which there is a lot to say, probably not now. You could argue that there isn't a policy where an insurance broker can now say, I think it covers this. And that is a real, real problem. So coming back to your question, people keep well away from it, very well away from it. And there isn't anywhere else. There are, I think there are about half a dozen expert organizations, what we call, where you go to find experts, agencies, agencies. I think about half a dozen. And I would say that within those, you'll probably find about a dozen or so names that fairly regularly come up, and nearly all of them are retired. I'm not retired, but I'm capable of retiring when I choose. But it is an issue because it's a real issue, because the thing about expert evidence is it's got to be relevant to the facts at the time, to a certain extent. And young people, I'm going to say something really controversial here, about me. I don't think you can probably safely be regarded as an expert until you've done about 30 or 40 years in the industry. I mean, I think, now there are exceptions to that, and I'll give you an exception because I've just used one. When we were doing the case in my day job, which is dispute resolution, not expert, I had to find somebody who understood very, very high-powered cars, very, very expensive high-powered cars, and one of these got up in smoke very suddenly, very unexpectedly. An expert in certain particular aspects of, and funnily enough, most of them are young people. You go around the companies that insure that kind of car, and you get a small coterie of people who are clearly regarded as the experts. But whether they make good experts in court is an entirely different matter. I think that really is the point. So there isn't anywhere at the moment you can go. People that I know, which is about, probably about a dozen of us, know each other well enough, partly because we're usually on the other side of each other from time to time. We all know where to go to find an expert. And quite often I'm asked, and I know the others are, do you know anybody that's an expert in so-and-so? And the answer is, well, I know where to find out. But then it's up to the solicitor or counsel, I think, to say whether they're suitable as an expert or as somebody that can give them the heads up as to
what you really want to know before you decide whether you're going to go any further, which I always think is a smart move rather than rushing into the CPR.
Well, I have to confess, I asked that question because I have had a lot of, I had that awful moment where my leading counsel in the middle of the case said, well, unless you can find a decent broker expert to confirm what we understand the law is, then we're going to lose this case. And it is a very daunting position for any solicitor to be in. And then I was reasonably horrified, and I did ring Beaver and the LMA, and we needed a fire. I think I rang you as well because we needed a fire, someone with experience in fire cases.
Yeah.
Actually, the PNLA network did in the end, which is I rang friend at Edwin Coe, who do a lot of fire cases, and you know that saved my bacon in the end. And she recommended a broker and an underwriter, which is even more hard to find, an underwriter expert willing to. And you know, and I think there is only one underwriter who will act.
There's one regular one, right? He's just been booked.
I know. I mean, which is a reasonably a horrifying situation. But basically, if any of you can find any brokers or underwriters willing to go on the PNLA website as specialists, I think that would be doing a marvellously supportive job for all of us.
Well, I would say that PNLA is probably in a good position if it wanted to actually make the running for improving the relationships with people that might be, because in my experience there are people out there, and there are very few people in the insurance industry that are interested enough in insurance to want to know enough to be able to give evidence. I mean, the truth is most of them are traders. It's mostly a commercial money thing, but there are those. I would say there's 300,000 people out here in the insurance industry, and I would think there's probably no more than 2,000 in the country that you would regard as people you'd like to have a conversation with about the technicalities of insurance. Do you agree with that? Mm. You know, it's that kind of number, but they're there, and they're bloody good. When I started in the industry, it was almost big C. It was 1970. We had people in the industry at that time who did nothing but policy work. You know, they drafted the policies, they checked the policies, they were the go-to people who really understood it. Mechanization and technology has swept all of that away. It simply doesn't exist. It simply doesn't exist. So there's nobody getting the training. The people that are doing it, in fact, are the people who are genuinely interested, and sometimes they're claims people, because you know they've been put through the mill, and I say through the mill, they've been put through an environment where they actually come into contact with solicitors and counsel, and some of them like it, and some of them. So in my career, I've come across a number of people who said, well, actually, I quite liked it, but my employer won't let me. And I think the target market is about 55-year-old. Those people who are coming up to retirement. And if you engage with them on some way of saying, you know, we'd like to hear more from you, or I don't know, you have to work out the way to do it. I think out of those, some of them would segue into saying, well, I can probably help you. And then as they move towards retirement or whatever, you can pull them out. But I don't think you'll get them from the deep-seated active underwriting fraternity, because I say the employers are simply saying, we don't want to be there. We don't want to upset the market by giving an opinion that might be controversial.
Yeah. Thank you. So our next question is for Kevin Wilcock. Oh gosh, just a minute, because he's next. We've mixed up the order a little bit. And he is from Wilcock Consulting Limited, and he is a cost lawyer. And his talk is obviously on costs and a practical guide. So Kevin, thank you very much for your guidance in relation to the many cost stages and aspects arising in a typical professional negligence claim. Given the key formatting to which you refer as the required forms for summary assessment, budgeting, and detailed assessment, would you recommend that solicitors should prepare any specific IT solutions to assist cost lawyers, for example, time recording using the set categories set out in CPR 47, practice direction, schedule 2, mainly phases, tasks, activities and expenses?
Thanks, Jonah, and thanks, Katie. Good afternoon, everybody. I thought I was going to go last, I'm slightly relieved, but it costs talking and lunch. So, I mean, I know you've all watched it, but just to, my tour was, it was a bit of a jog through. There's lots of stuff, obviously, on cost generally, but I was dealing broadly with some of the things that you have to deal with on practical level, dealing with budgeting, summary assessment, and detailed assessment. So it's quite a wide range of stuff. But the question, thank you very much for putting it to me. It's a question that has been asked a few times over the years. Like when you look at that question that asks what specific IT solutions do you ... I mean, that probably fills most people with dread. And when I've been asked that question quite a few times from solicitors, they at first are quite relieved that the answer that I gave then, which I would still give now, which is I don't think you need to think about necessarily changing your IT structures and systems. And they sort of breathe a sigh of relief, because really it's about, the reason for that is because most litigation partners have already got time recorded systems which are good enough to deal with what you need to put in there to deal with the likes of budgeting, summary assessment and detailed assessment, client reporting and billing and all that sort of stuff. Really it comes back to, or comes down to behavioural solutions, really. That's as good as what you put into it. So I think really it comes down to, you don't need to change your systems, but you need to think about what puts you in the best position to provide the most effective, efficient preparation for your client, and then you're best prepared when you come to deal with things you need to do call facing wise. So I think if you have to do anything, I think to spend some time thinking about, because most of your stuff will be investigation, and you probably would be needing to be involved with cost budgeting at some point, although that's at the moment that's up for consultation, so that may to some extent not be as prevalent as it is at the moment, but really you should be thinking at least what phase or aspect your work that you're doing falls within. If you find the time to split it out, because obviously you're going to say, in 10 hours doing all this stuff today, it might fall into different phases. You could just find some time to split that out at that point. It's going to help when it comes to client management, strategy, and also helping the likes of us and the board when it comes to the budgeting and ultimately and cost recovery with detailed assessment. Most of the time when we're involved with horrible, messy, detailed assessments, they are often the cases where people haven't done that at the time. So, a lot of the work that we do is, getting people out of it at the end when they could have done stuff, didn't we? But hey, that's fine, in a nutshell.
Thank you. I think I've worked in firms that have had sort of systems in place to time record, which forces you to time record in that way. So you have to get your head around it. You have to do it if you want to click OK and put your time down and get up to whatever your chargeable target is, or however many hours you've got to get on the clock. And then I've worked in firms that don't have the systems, and then when you aren't forced to do it, it is very easy to slip into bad habits and time recorders for 10 hours reviewing the file. I don't do that. I don't spend 10 hours reviewing the file, but it is very easy not to split it down in that time, isn't it? You're not always thinking about
I mean, don't get me wrong, if you have to start thinking about what phase is it in, what task within that phase is it, what activity is it, who am I talking to, then you've got enough to do, thanks very much. But you know, a lot of time when there's a drop down field that you can't afford the time to put something in, it'll put it, they'll just pick something on most departments. Someone else, later on.
We're not any of the partners here.
No. It takes all breaks, timekeepers time recorded. So yeah, I mean, you know, I don't think to some extent things are going to change that much, but you know, to say anything, you know, if the quality of information is good at source, then you can report that. You've got, you know, you can report that better, you know, quality as well. I've been talking about this for 6, 7, 8 years. Since before the implementation of the electronic bill, and you know, we still get instructions now where no one's done anything already 6, 7 years ago. Because for the most part, you know, most of the cases don't go into detailed assessment, and when it does, present to Kevin. Thanks very much. That's mine.
We know where to send our tricky cost bills to. Do you want to make notes?
Yes. Next question is to Rachel Ward of Indemnity Legal. She gave a talk on the thorny issue of third-party rights against insurers, which I think, as we all know, the first act was in 1930, and then for some reason the 2010 act took many years before it became into force. So Rachel, thank you very much indeed for your talk about third-party rights against insurers, and in particular the need carefully to check that the 1930 act could still apply, which is a bit of an elephant trap. One further point in assessment must be, as far as solicitors are concerned, the insolvency of insurers. Some 15 SRA participating insurers based in various jurisdictions have become insolvent in the last 20 years. What steps would you suggest to solicitors acting for potential claimants when considering using third-party rights legislation in this background?
Thanks, Katie. Thanks for the question. Yes, we've all heard of lots of them. Enterprise Insurance Company, LAMP as well, AMPA, they all wrote solicitors PI. So I think the flavour of your question was maybe hidden away on one of my latter slides, and just one bullet point I didn't have time to get onto. But in a third-party rights against insurers context, if a client has a potential claim against a solicitor, and then you suspect that the solicitor's firm may be in financial difficulty, then firstly, you're going to check whether the firm is a relevant person. We talked about this on the webinar, under the Third-Party Rights Against Insurers Act. So that's if they're in administration or liquidation being wound up. If that's the case, then the Act is engaged, and then your client has a right to certain information about the firm's professional indemnity insurance cover. So crucially, the identity of the insurer, but also terms of the policy and whether there are coverage proceedings and the issues there. So first of all, I would suggest contacting the former directors of the firm, or the firm's insolvency practitioners, to request information about the firm's professional indemnity insurers. Or if you get directed to the broker, then they can often provide that information. Now, at that point, if it then becomes apparent that the professional indemnity insurer is insolvent, that might not actually be the end of it for your client, because if the firm had sufficient cover in place, that's still valid. The insolvency doesn't change anything about that. But you're going to now need to direct your inquiries about the insurance and everything to, and also any subsequent claim to the insurer's insolvency practitioners, or claim handlers or agents that they've instructed. So how do you find out who they are? Well, you can search an insurance firm on the internet, at their page, or you can go to the FSCS website, that's the Financial Services Compensation website, and you can search for the insurance firm there.
speed it up. But the FSCS, they don't tend to handle claims under insurance policies, but it's the insolvency practitioner, the claims handler, that's going to do that for you. But if the solicitor's firm is eligible for FSCS cover, then the FSCS is going to fund the payment of a valid claim. It's valid in terms of under the insurance policy, and if the underlying claim is successful. So they're going to fund that claim if the insolvency practitioner accepts the claim into the estate. I've got lots of points to say here. I have to try and wrap it up, I think. So the important thing to say today is that if you find out that the insurance company has gone bust, you need to find out whether the solicitor's firm has the benefit of FSCS protection, because if they don't, it's probably not going to be worth your client pursuing the claim, because even if your client's successful and you bring a claim and you bring declaration proceedings, you name the insurer, you name the solicitor's firm, and there's no FSCS protection in place, then your client's going to rank as a creditor in both those insolvencies. So that's the first question to ask the insolvency practitioner that you get in touch with.
Thank you very much. Right, Rocco, we've left you to the last, but you've got a very important question to ask you. Right, so Rocco is from Harbour Underwriting, and his talk is titled "Improving Your Chances of Obtaining Funding and ATE." So Rocco, it's lovely to see you again. So we used to work together quite regularly, didn't we? And it's lovely to hear. It was lovely to listen to your talk, especially after so many years of involvement in the market. So you mentioned the possibility of a chat before approaching you with all the information and completing the form. So what stage in the dispute would you consider it's best for that chat to take place? How would the chat work for complex matters or unusual factual situations?
I mean, the chat is a really good question, actually. The chat can take a different sort of variety, because part of the initial chat could be a conflict chat, a very simple chat. As you can imagine, whether you're a funder or an agent insurer, let's just say you're thinking of suing a firm of solicitors, it's worth having a call to make sure this is a firm of solicitors. That provides a lot of work to that funder or AT insurer, because there could be commercial sensitivity around that. So, that type of chat, won't take very long. Equally, it might be that it might be something similar with a barrister as well, because again, I mean, as AT insurers and funders, we're pretty well connected with the barristers and chambers. So again, there's commercial sensitivities there. There could be sensitivities around suing brokers, because brokers provide work to us. So the conflict check, I think, is probably a good first one. If it's a case that might have been in the hands of another law firm, I think it's worth picking up the phone as well, because we might have seen the case before. And that's happened to me, where you just broadly say, well, I've seen it already as a case. I saw it, whatever it was, 4 or 6 months ago. What's changed? And sometimes nothing's changed. You might have already declined it. Now, you might as well have that heart to heart. You as a law firm will know you've taken it on from somebody else. So you might as well, whether you're an underwriter or a funder, you should be able to say I've seen it before, and that's probably telling you something. Now, unless something has happened, then of course evidence does trip out. Counsel has been reapproached, etc., etc. I have seen cases like 2 years down the line
So it does happen. There's been a long lag and things have moved on. So again, that's a sort of a second tier type of conversation. But coming back to where I think your question is really directed, it's very much around, before you fill in whether it's an AT proposal form or start preparing a submission for a funder, there's quite a lot of work involved. And I do think it makes sense, as I said in my talk, to have a conversation to make sure it might be within appetite. Broadly speaking, professional negligence cases are. I mean, it's given, it's sort of within a sweet spot. It might be that there's, as I say, there are commercial sensitivities. Otherwise, it should be. Certainly, auditors, it's remarkable how many AT providers, for sure, not funders, but I think AT providers are a bit nervous about professional negligence claims against auditors. I'm glad to say I'm not in that boat, but there are those who are. But I think that probably the best stage to make that call is where you're in a position where you've made a reasoned assessment of the merits. Now, that might be on the back of your own assessment as solicitors, and you might say, we're about to get counsel's opinion, and of course we'll come back to you afterwards, but we actually think that this is a meritorious claim. As an law firm, we've done some work on it, etc., that's fine. You might want to make a call after you've got counsel's opinion, which might validate your opinion. But I think the earlier the better, as early as possible. I mean, ideally, it's client has come to you, it's yours, it hasn't come from a law firm, and you've built up the case. Then, I think effectively at that point in time where you're looking at the letter of claim, what if you've got a letter of response, a substantive response? Definitely, I would say before the issue of proceedings, because there is this thing about adverse selection. So I know that's a phrase that's used a lot by insurers, less so by funders. But I think timing is important. But I don't think anyone's shy about spending time whether from as an AT underwriter or as a funder. I've lived on both sides of the fence, so I have been a director of litigation funding as much as an underwriting director. I used to get random calls as a director of litigation funding where, it was from the claimants themselves. You can imagine what conversations I had. I've got a really good case, it's told me it's worth a load of money, and and you're having to sort of charm your way through this conversation. And sometimes you have a conversation with a solicitor who's just been instructed, who really doesn't know very much about it. I've just got a pile of papers, I'm just getting my head around it type of conversation. To be honest, don't be embarrassed about it, is all I'm going to say. I think we've all seen it, whether from a funding side or an underwriting side. I wouldn't get embarrassed about it. I think you probably have a gut feel when to make a call. I've given a very long way of getting to, you've probably got a gut feel. I know it sounds as if I'm copping out, I'm not. I'm trying to answer.
That's great, thank you. Thank you so much. About 3:30. Should we see if there's a few questions, or does anyone have any questions? Any additional questions they'd like to get, Helen?
So I had a follow-up actually, Rocco, about your comment that some insurers and or ATE insurers are a bit nervous or cautious in their approach to auditor professional negligence. And I wondered whether you could elaborate on what you suspect the reasons for that might be.
I think it's probably a little bit historical. There have been some unsuccessful claims in the past, and which hit the headlines. And it very much depends on the underwriting you're approaching. You can't. It's the same whether it's the lawyer, a barrister. Everyone's got to have a sense of comfort in what they're looking at. And I think underwriters probably got certain roles or Stevens racking in their memory, and probably unaware that there are actually some really good claims out there. I'm glad to say I've insured some of them, but you know, unless you stray from your comfort zone, you tend to sort of go, you know, and particularly if you're really busy, it's sometimes the easiest answer is to say no. And, you know, I have to say, I thought that there are about patent disputes. Again, I'm wary of them. I don't have an engineering degree or a scientific background, so I'm automatically wary of them. But if you look at them, and they're jolly hard work, and I think it's a question of, you know, whether underwriters just get comfortable with it. I'd also say, given your specialists, that you spoke to, there's very few professional negligence claims against office holders. I'm glad to say one I'm sure came good. It went all the way to trial, it came good. But again, these are the type of areas where I got the distinct impression I was almost like the only insurer in the running. Obviously, all brokers will tell you, there's lots of interest in this case. You know, brokers have got a job to do. So, but I genuinely got the impression I was probably the only insurer who was genuinely interested in this case, which is why we found cases. It went all the way to trial. So I mean, not exactly what I wanted, but I mean, it went to trial and we won. So I mean, you know, so you can't ask more than that. But so ultimately, our judgment, our connected judgment on this case was right. But yeah, so I think it is about. There's so much about people's sweet spots, and as soon as it's outside the sweet spot, the easiest answer is no.
I remember meeting Susan Dunn before she joined Partner.
Oh yes,
and yeah, is that the insolvency?
Yeah.
Because I was doing I was an R3 member in insolvency working in Bristol. As was Nigel Mallet, who you may remember, who formed the PNLA with me. So, and I remember that I remember being really struck by how brilliant this whole idea was of AT insurance funding. But I do remember having had lunch with her and frank conversations about how difficult she did find it to convince insolvency practitioners of the benefits of it. Yeah. I mean, you know, I just thought it was and I did suggest actually at that time doing a similar professional negligence one. But to say that didn't get off the ground. But then you piled in very shortly afterwards, you with the PNLA AG scheme. So that operated for many years before LASBO, unfortunately, put the kibosh on that. But I would have said, does it still the case then that you think Harbour and Susan probably are particularly suitable for insolvency cases?
Yes, I mean, with litigation funding insolvency cases, obviously it's all about the numbers.
Yeah.
Back in the days in North End, Susan was at my end litigation funding. There they were looking at all sort of modest value claims.
Right.
But now, when you think about so many litigation funders, they look at claims. I remember, I'm going to go back down memory lane. When I was a director of litigation funding at Harbour Litigation Funding, I remember getting these calls and speaking with solicitors, and you know, they'd be telling you about their client's case. This type of call that Jane was asking me about. I've got a client, I have this, I have that, you know. And then I say, so what's the claim value as pleaded or less claim? Oh, it's worth 20 million. And then you start working through it, and then you end up realizing that when you start whittling it down, it's probably be 7 or 8, okay, as a realistic claim value. Doesn't stop you claiming your 20 million. And then you get to this bizarre position, which I was in, and I said, you know, expressed quite like this, but you finesse the message. But I said, I'm sorry, it's too small for us. Now, it's a ridiculous thing to say. How can you say a 7, 8 million? That's your assessment, okay? And how do you end up saying it's too small for you? But the reality is, from an investment appetite, litigation funders are working on a claim value. So they're trying to deploy capital. If you've got a fund of 250 million, if you start giving out funding of 1-2 million, it'll be there forever trying to deploy it. So you're looking at your appetite is for the bigger cases, the group actions that Jonathan was talking about, the claims and the competition appeal tribunals, looking at bigger size claims. And so, coming back to your question, if yes, they do have an appetite for insolvency related claims, but probably need quite a big number attached to it. That's the problem.
Sorry, just another question. I don't know whether it was you, so I'm asking this quite consciously. But I think one Blackfriars was funded.
It was, and it was also insured. And I'm pleased to say I declined it.
Right.
Sorry. I'm glad to say that wasn't one of mine. But yes, again, but no, on a serious note, obviously the insurers on that. You can imagine an underwriter will be thinking, I'm never touching that little of these cases, because it's going to be an instant sort of reaction, isn't it? And then you've got the rest of the market who will know about it, and and will be thinking, well, that didn't work out very well, didn't it? And everyone will be instantly thinking there's something inherently tricky about these types of claims. But maybe it's not that. It was just, it wasn't the right one to back. I can't remember exactly why I declined it, but I did decline it. But actually, it's a funny thing. I mean, it's something that we probably all have in common in this room. It's lovely when when you have your successes and you ask and glory, but sometimes your successes are bullets that you dodged as well. And I've got a running list of cases that have gone to trial, lost, and I didn't decline to insure them. And of course, you don't put out on it. But actually, it's sort of like trophies as well. Because someone on the line got it right. So they're equally valuable.
Questions? Helen?
I've got a question for Kevin. How much experience have you got on varying cost budgets, and do you have any tips?
Varying cost budgets, yeah, I mean, they thank you for that. No, they used to be not very common, didn't they? But they're kind of doing. I've done a few different rights, I mean, they say that if you're looking like you're over your budget, then you should really think about applying for a variation as soon as possible. People are worried that they may not get that variation, so they sort of wait until the end to see whether they can go in, if they win the case through good reason to depart from the budget. But I mean, the advice I'm hearing barristers talk about, it sounds like it should be, and the courts are probably a bit more receptive now to applications to vary. So I guess the advice would be to not be afraid to apply.
Any more?
Just on the third-party rights against Insurers Act, remember you might have a claim under the successor practice rules. So if the insolvent firm, if the firm you're suing has gone bust, and its insurers have gone bust, it may be that the lawyer who was dealing with the matter has joined another firm. That firm qualifies as under the successor practice rules, which are quite complicated themselves. So you need to be a bit careful about that, because if the solicitor's firm stole money, that's a deemed event at the time. But if it's actually a professional negligence claim, then it's on a claims-made basis. That may be a way of getting around Katie's horror of finding this duty to sue. And another way maybe is suing the salaried partner or the employee if it's a partnership, because they may be potentially liable. Of course, they'll be under the 1 million cap for claims under the financial services compensation scheme. So that's my little addition to the party responsibilities.
Robert, does that affect your funding decision if the I mean, how do you feel, say, I mean, I've been doing a lot of claims involving Alpha, so I know, funny enough, I was doing a claim for a solicitor relating to Alpha, at the same time as a claim for a client against a solicitor insured by Alpha, so it was a really bad day in May 2018 when they went down, but I have been following the progress of that insolvency. I mean, there are millions of pounds sloshing about in Denmark. I don't know when they'll appear, but it doesn't appear to be utterly hopeless that sooner or later some of them might go. But how would it affect your appetite, or if funders' appetite, if you're acting for a claimant with a claim against an insolvent insurer? What would you feel you'd be able to do?
Yeah, well, from a funder's perspective, they think of enforcement first, and so I think they probably turn away from it. You know, if they can't see a clear line to a recovery, they would just so the first thing they should they wouldn't even engage in the merits or anything like that. Just think, you know, how could we enforce judgment and costs?
But isn't the insurance industry pretty strict about reserves and the regulation and the SRA participating in insurance? So surely the whole idea is that there should never really be a situation an insolvent insurer's got nothing. Surely it's more a question that they're having to stop taking on insurance because they haven't got their reserves. So surely there should always, in theory, shouldn't there, in the insurance industry be, you know, nearly enough reserves of capital to cover?
I think with Alpha, you might have to correct me here. I think with Alpha, the initials started taking on new business. But a couple of months later, I think they went into a full bankruptcy process. So they called it bankruptcy then. So rather than liquidation. And so, you know, in that scenario, see a funder would definitely say.
That's interesting, yeah. There was a bit of a theme, I think, of insolvency. I know it was mentioned by Jonathan and Rachel, but also by the Mishcon and Mishcon Karas. They were talking about auditors' negligence claims in Hong Kong and here, and Mark Davis won the Asset Code case. So I'm beginning to feel I think you'd have to be living in a different planet not to think that insolvency is on the upturn at the moment, isn't it? That the economy, alongside the surge of lender claims and repossessions and lender claims that I don't know if anyone else has got any thoughts or observations about storm clouds gathering.
Peter. Peter's got any comments on that? No?
I'm just waiting for it.
Did I interrupt someone?
No, I was just going to say, historically, the sessions is good for litigation, aren't they?
Yeah.
They are.
Past doesn't necessarily determine what's going to happen in the future, but not the right.
Well, I'm keen on the lenders. It's lovely to see several here and more of the drinks, because basically PNLA was formed on the back of the first wave of lender claims, where we all discovered we were sort of sitting on our own with deluges of casework coming down. Pretty lonely life, trying to reevaluate, you know, massive caseload and not having a conference to go to or anyone to, you know, to talk to. So the core group, and it was then and remains, you know, that you know, we are the association for the lender claims group, and I hope we're not going to let them down. We'll carry on being there for you in the next round.
Okay. Hey, there's no more questions. Shall we wrap up and
Yes,
go and get something to drink? Yeah. Did you?
I was going to say just well, one very important closing remark, which is this conference was entirely organised by Jana. And it was a hell of a risk. I mean, it's the first time she'd been asked to do anything like this. And I wanted a very fresh approach to the conference. I mean, I think people, many of you have known me for many years, but I think it's important for the younger people doing professional enthusiasts about it to, you know, sort of be seen and coming through. And I'm just so delighted and you know, really pleased with how it's gone. And I think it's an absolute fantastic conference. If you haven't had time to listen to it all yet, I do recommend it. I've listened to them all again quite recently, and there's really an awful lot of material in it. I'd say in summary, it's a conference which very clearly highlights the doors that are opening and closing in a number of aspects. I mean, people who aren't here today, for example, are all those who talked, there were 3 talks about surveyors' negligence, for example, as well as the auditor's negligence, in addition to those topics we heard of today. And I do think that, you know, it's a hugely useful conference from that point of view, if you're sort of looking at where you should be focusing on in a professional negligence context. So thank you very much to Jana.
Thank you for having me.